So, welcome to Beyond the Gavel. This is a podcast where we step away from slogans and sound bites to examine how serious litigation is actually practiced, case by case, and as you well know, jurisdiction by jurisdiction. So, in today's episode, I'm joined by Anna Berezovski. She's a New York trial attorney and partner at Lichtman and Berezovski, whose practice sits at that sharp end of medical malpractice, civil rights litigation, and high-stakes professional negligence claims. She has more than 14 years' experience in the New York courts, and she's built a formidable reputation for defeating summary judgment in complex medical cases, often where others have already advised caution or even retreat. So Anna's work is characterized by disciplined case selection, rigorous medical analysis, and a clear-eyed understanding of the realities of modern litigation, the cost of experts, the difficulty in securing meaningful discovery, and the psychological burden carried by both clients and lawyers in cases that can take years to resolve. So her perspective is shaped not only by courtroom success, but by the sustained exposure to cases arising from institutions such as Rikers Island, where law, medicine, and systemic failure intersect, and sometimes in most uncomfortable ways. So in this conversation, we're going to explore how experienced litigators decide which cases should proceed, how medical issues must be narrowed rather than embellished, and where AI tools can assist and where they can't assist without undermining professional judgment. So this is going to be a thoughtful discussion about restraint, strategy, and responsibility in litigation. So Anna, thank you so much for joining us today on Beyond the Gavel.
Thank you so much for having me. It's a pleasure.
You're so welcome. I loved speaking to you before, and I just think our listeners are going to get a great day today because you have that experience in the New York system and Rikers Island. How has working in that jurisdiction shaped the way you treat medical malpractice and litigate for it?
Well, in our jurisdiction, and I'm admitted to practice in the state of New York, second department. The medical malpractice cases are not easy to prove. So they're still tough. It's a tough litigation. You're facing insurance defense lawyers who are aggressively defending the doctors. So everything begins with selecting the cases. This is the key. You select the cases, you select the clients, and upon selection, while you talk to the client, you already think about defending the summary judgment motion. That's coming in 99.9% of the cases. So if at the beginning of the case, you don't think you can defend the summary judgment motion, you should not take the case one. The case requires, as you know, it's very, very expensive. First of all, you must consult a physician before even filing the case. So you begin with collecting the medical records, which you already start paying out of pocket for the records. You collect the records and you consult your physician, who's supposed to be a licensed physician in the state of New York. He's not supposed to be, but it's better to have someone in the state of New York or the tri-state area, Connecticut or Pennsylvania. So these are the experts we're working with. And then the expert is supposed to tell me whether there is a case or not. All right. And you have to keep it in the back of your mind, even if the expert approves the case at the initiation process, upon filing, it does not mean that that expert would support your case when we get to the summary judgment motion. So that's something to keep in mind. Okay. A lot of times, or sometimes, they just wouldn't support anymore when we have all the discovery.
So tell me a bit about the New York system there. We have people from around the world, Australia, New Zealand, Canada, UK and Ireland. Tell me about summary judgment. How would you explain that to lawyers from other jurisdictions?
So basically, after the discovery is over, after we're done with all the depositions, after we exchange all the documents, we file something that's called a note of issue and a readiness for trial. We're telling the court that discovery is over and we're ready to put this case on a trial calendar. And then from the moment we file the notice of issue, usually the defendants have around 90 days to file a summary judgment motion. And in medical malpractice cases specifically, they would do that in 99.9% of cases. Most of the time, they would do that. All right. So what they're telling the court is, in that motion, they are asking the court to dismiss our case from two reasons. First of all, they're saying there is no prima facie there is no prima facie case, meaning that the defendant was able to establish prima facie that the doctor did not depart from the standard of care. And even if he did, the injuries that the plaintiff sustained were not caused by that departure. Okay. Usually that motion has to be supported by specific relevant experts. And from one reason or another, the defendants are always able to find experts to say different things that you wouldn't even expect the doctor to say, but they would. And then as a plaintiff, you have to oppose this motion, and you also have to retain your own experts. And then all you have to do on a motion to oppose the motion for summary judgment is to raise an issue of fact for the jury to decide. So when we oppose the summary judgment motion, we make two arguments. First of all, they fail to establish a prima facie case because their experts are not refuting all the claims that the plaintiff did in the bill of particulars. They have to address all the claims. They can't just address one of the claims. They have to address all departures from the standard of care. They usually don't address all the claims. They are addressing only what makes sense for them, from the medical point of view. And then we're telling the court, even if they made a prima facie case, the case has to proceed to trial because the plaintiff raised an issue of fact with our own experts. Okay. And this is a very complicated process, and it's very expensive. And this is why you have to consider this process when you take on a case.
So what sort of cost, I mean, not specific, but average cost to get it to that point on a reasonably complex case? How much are you talking about ish?
Just to get to the summary judgment motion?
Yeah.
Well, couple of thousands just to get there. Maybe 5 to 10,000 to get there.
And the other side are spending that as well to try and refute it. Interesting, because in this jurisdiction, we call it find the fundamental question. What is the fundamental question that you're going to ask the jury or the judge to consider? And that's really what you're saying. It can be flaff on this side and flaff on that side, all cancelled out. But what is the nub of the question? What is the objective, fundamental question you're asking the court to say, is this right or is this wrong based on the facts? And really, that's what you're doing, isn't it?
No. So the court does not decide the substance of the case. The court just has to say whether the defendant met their prima facie case, and whether or not the plaintiff raised an issue of fact. I had only one case when the court decided that the defendants failed to support their prima facie case because their expert affirmation had 3 paragraphs. That's it. Okay. And the court was like, this is ridiculous. You didn't even met your prima facie burden of proof on the summary judgment motion. And even if you did, the plaintiff still raised an issue of fact for the jury to decide. But in 99% of the cases, the court will accept the defendant's expert's affirmations, and they were going to be like, okay, the defendant provided enough support for their prima facie case, but the plaintiff raised an issue of fact for the jury to decide, and therefore their summary judgment motion is dismissed. The court is not going to decide the substance of the issues that are raised in the case.
It will decide whether there's a question to answer. It won't decide the substance of it. But whether there is, based on the facts, a question to answer, that's what we call the fundamental question. Now, that's interesting because when you get that far and you've spent that sort of money, if we go right back to the beginning, how do you make a decision based on your experience as to whether you're going forward? You know that the majority of people walking over the door have complaints, and some of them are coming to you basically for a second medical opinion. So how do you make a call as to whether you're going to carry a case to start asking experts or not? Do you ask on every case? Or how do you make up your mind looking at a case whether this is worth the time and effort?
That's $1 million question. So first of all, we are looking at cases with severe injuries. Unfortunately, we can only afford taking plaintiffs who suffered severe injuries. Cannot be like a scratch or something like that. Then Then we collect the medical records and we'll look through the records. And this is when we started using CoConsole. It's an AI platform that is amazing with going through the medical records, sorting out the issues, and see what's going on. And then if so, we have to prove two things here. You keep it in mind, the departure. So whether there is a departure from the standard of care and whether this type of an injury is a normal risk of the procedure. If this is a normal risk of the procedure, most likely we will not take the case. The only exception would be if the plaintiff, the potential plaintiff, was a high risk and then should have been consulted about the heightened risk of the procedure, which sometimes happens, that the plaintiff is more vulnerable and still the physician decides to go forward with a procedure that carries higher risk than usual. So those things you consider before filing, and then you Google the procedure, like you do basic Google search. Now you chat GPT the procedure, normal risks, all type of stuff. You educate yourself on the medical issue. And then once you decide there is a case based on your research, this is when you consult your physician. You have to consult before filing. You actually sign an affirmation of merit where you say that you consulted a physician and that there is a case based on your consultation.
An affirmation of merit. I like that. And I get what you're coming from. I mean, I'm just looking recently at a case of bariatric surgery for weight loss. And no mention was ever made to the client about, injections, about weight loss, not to find a point of weight loss injection, never mentioned. And that plaintiff died as a result of a bowel leak. After the surgery, she was heavily overweight and got deep shock and died, but never, ever had it been brought up to her that she could have some of the, I'll not mention the names, but some of the weight loss drugs, which, given her background and her breathlessness and all the rest of it, put her at a considerable risk, because even at the consent stage, she wasn't given, they just, oh yes, operation, because the type of clinic, that's what they did for a living. So I get where you're coming from. You got to be clear about what you're looking for, and you've got to have an idea of what alternatives there might be and why they weren't discussed.
Right. The alternatives have to be discussed. And actually, on the summary judgment stage, you have to also oppose the informed consent issue. And this one is tough to oppose unless there was some heightened risk of the procedure, because as soon as the patient signs the consent form, it's hard to argue with.
Yeah.
Okay, it's just, yeah, it's in general hard to argue with medical records. So another thing you look at the medical records is whether the patient refused treatment from any reason, and even if they didn't sign a consent form, it's a problem. Okay, if the physician documents he refused surgery, refused this treatment, refused that treatment, it's going to be a huge problem for the case, because the patient has a responsibility to get better.
Of
And
course.
if there is a referral that the patient did not follow through on the referral, it's another huge. So you're looking for the problems, that potential problems that might come up in the case. We had
Yeah,
a
contributing
case.
negligence is very important, isn't it? What the client does. So that brings me on to then how you work with doctors and experts. What's the difference between an expert who strengthens your case and one who is liable to weaken it, a strong case? How do you look for experts, and how do you choose who you're going to use?
So in general, at the beginning stage, we have an expert we work with for years, and we trust his opinion, and he's pretty straightforward. And we believe that he consults us not because he wants to get paid, but because he either believes or does not believe in a case. So first of all, it's a trust. It's a personal trust issue. Okay. We had I, I had bad experiences with experts, and one in particular who told me there is a case for failure to diagnose a pancreatic cancer. It's a radiologist. And then he disappeared. And then I filed the case. I was trying to reach him, and he eventually said, "Oh, well, I'm sorry, I cannot support your case. I'm not sure why I supported it at the beginning with no explanation. So this is obviously not an expert we will be working with in the future. But at this point of time, we do have a couple of experts we believe in. And I believe that that expert will tell me, well, there is no case, don't even spend your money, you know? It's just a
Yeah.
personal relationships, honestly. It
And that
depends.
is, and it's also a thing about time because time changes a lot of things and people have time to think, like seems to have happened in that case. So, how do you keep your clients engaged knowing that it's going to take a long time, to get a lot of these things actually sorted for them? How do you keep them motivated over that time and keep their expectation going?
Well, basically pick up the phone call. If the client calls you, you have to return the call, but usually it doesn't take us that long to sort it out. I mean, as soon as we have the records, and I even tell the clients, if you want a faster answer, get me the records. It's so much faster for them to get their own records, especially now with electronic access. They can just email me the records, and that's what one of my clients just did. There were like 4,000 records from 2 or 3 back surgeries. So he got me the records electronically. It's that
Yeah.
easy. I put them through co-counsel and whatever issues, like what I do then after co-counsel, I give my co-counsel analysis to my expert to save him time to go through the records. And he likes it. He likes that everything is ready for him. Doesn't have to go through 3,000 records.
Yeah,
He
the
can get the
knowledge is
idea.
there and all the highlights are sort of pulled out. Tell me more about AI. When did you start using it and how are you finding it?
So I started heavily using it, I think, like a year ago, and it made such a huge difference. And especially, I love the co-counsel platform. I'm not sponsored, but I love them so much because of the ability to go through the medical records. And I noticed now they have different functions where you can compare the records. The AI can also spot what's missing from the records. So that's really important because this is something that our experts were doing. They're like, okay, this is missing from the records, that is missing, and AI can spot inconsistencies, what's missing, risks of the procedure, and it can either tell me whether or not it thinks there is a malpractice or not. So, or what should have happened for that to be a malpractice. Okay. And then I do use ChatGPT to educate myself on the medical issue, like what's the surgery is about, what, like you can even ask the ChatGPT like how can this organ be damaged in this like surgery, what should happen, because usually the operative reports don't tell you that the whole entire story. Based on the operative report, everything is great. So you have to understand like what's supposed to happen like anatomically for this to happen. You know what I mean? You kind of have to educate yourself. You have to know what the issues are. So this is when AI is amazing. It can even draw a diagram, of course, if you really need an explanation or if the issue is too complicated, and like just explain it for dummies. Just explain it like in a simple language. You know what I mean?
I'm
It's
not going to
amazing.
say very much, but I mean, again, when you're going to court, it is that, medicine for dummies because, with all the will in the world, a jury is not the brightest as far as medical things are concerned. And it is the function of an expert and the function of the lawyer to make sure that what's presented to them is intelligible to them. So that's an important thing you're bringing up about your expert and your own research. If you don't understand it, you're going to have a very bad job in helping somebody else do. So I really
Yeah.
appreciate the way you're saying about that. What would be the disadvantage of AI? Because one of the things I find, you've mentioned a particular brand. If you ask it, prove this for me, it will. If you say, prove the other for me, it will, because not only are you using it, so is the defense. And you can actually ask it to prove what you want. And that could lead to difficulty. What difficulties have you found with AI?
So I think especially ChatGPT, it's programmed to please you. So you have to know that it's first of all, it hallucinates, it's lying to you. So if it refers you to sources, you have to triple check your sources. Of course, you cannot do a legal research. Yeah, absolutely have to read all your cases yourself. And we don't really, so remember, everything I do in ChatGPT, as far as research and stuff, my expert has to support that. So if the expert is going to say this is wrong, whatever, so that's wrong. But usually with specifically medical research, it gets like the majority of it right. Okay,
Yeah.
it's not, it's able to explain the basics of medicine and how, and the basic risks of the procedure and stuff like that. So that's, it doesn't hallucinate there. What the problem becomes is when people rely on its legal research. This is something you cannot do.
Yeah.
So
Or
with
it's what Reagan said, isn't it? Trust but verify. You get it, but you must
yes.
verify it. You must get the evidence that backs where it goes, and anything it comes up with, you got to go and get it to see that that's
Yeah.
actually correct. Yeah.
Yeah, so
Yes.
I noticed that even if you, even co-counsel has Westlaw connection, that
Yeah.
Westlaw can do legal research, and still you really have to read each and every case because there is some problem that the machine has at this point. I'm sure it's going to get better with interpreting the cases. And this is where you can get in really big trouble with the courts. And we had people here getting sanctioned and stuff like that because when you read it, the analysis is amazing. But then when you go and read the actual case, it has nothing to do with the analysis of the case. And you can present it to court. You're going to get in huge trouble. But for the purposes of medical malpractice, there is no big legal research because the law remains the same. What you're working with are the facts of the case. And you just have to adjust the facts. The law doesn't really change. It hasn't changed in a while.
Yeah.
So
It was interesting. I was looking at a case again recently, and AI said there's a multidisciplinary team meeting, and it said the doctors are indecisive. And because they were indecisive, this was below the standard of care. The doctors made a decision to wait for a week. And it was made by a number of people. So it wasn't indecision, it was a decision to wait. But AI interpreted that as medical indecision. And
yeah.
so we had to get around that one, to talk it. I mean, there were other things in it, but I mean, just like you say, AI can hallucinate and come out with things that it thinks because it can't read the mind. That's the big thing. The human mind is thinking and processing like you are, and AI hasn't got that yet. It can do the facts and it can do it boldly and do chronologies, but thinking, real thinking, is still your province as a lawyer and my province as a doctor. And so I think it's coming, and we can't. Other people have washed their hands, and I'm not using this ever. And I said, you're in for a big shock if you do that. It's like saying
Yeah.
you're never going to use the mobile phone. Yeah.
Yeah. And another problem AI has is that we have more and more clients coming up with AI analysis of their case. And it's completely wrong as far as procedure. So they're like, why don't you do this now and that now? And I'm like, this is wrong, we can't do that. And then we end up, it's like AI battles, like we end up arguing with AI and with the client who trusts AI to do our job, and that becomes a problem because it's programmed to please you. Remember that. And I'm trying to tell our clients, like, it wants you to be happy, so it comes up. So for example, they can download all the whatever filings, and then AI comes up with problems. I'm like, there is no problem here. So this is another, which is welcome. The client has to be involved in the litigation, but I guess doctors feel it more because I used to Google problems, and when I got to the doctor, I'm like, this is what the Google said, doctor. Now I feel it on myself.
Well, yeah, and the other thing that I have seen is that they'll put their stuff into AI. They'll get an answer which says you're missing this, this, and this. So they will add that and run it again. And they'll
Yep.
add it and run it again until it says yes.
Yes,
And then they'll
exactly.
give that to you and say, there's what AI said. Or they won't even say that, but it's obvious from the headings and the way it's structured that, this isn't even their first language, and yet it's perfect, high level structure, so interesting. So AI does have a place, and you're clearly pointing that out. And that's going to become more and more to the fore. Anna, this has been a wonderful chat. I think our listeners have got a heck of a lot from listening to you today. You're obviously very experienced. You've been brought up in the fire of New York, and you obviously have your mind very clear. So thank you so much for sharing your wisdom with everybody.
You're welcome. Thank you for having me again.